Hi, I'm Ruby Wake, and today I want to discuss S&T, or Special Needs Trust, also known as a Supplemental Needs Trust. So an S&T is really designed for beneficiaries or individuals who have some type of disability and are on governmental assistance such as Social Security or perhaps Medicaid, and have received money that's threatening their qualifications for these governmental programs. So what is codified in both federal law and in some state law is the idea of an S&T, or Supplemental Needs Trust. You will hear those words interchanged. They mean the same exact thing. It's a trust that's designed to supplement, instead of supplanting, governmental benefits that someone may be entitled to. There are a few different types of S&Ts. We have what's known as a first-party S&T, third-party S&T, and then we also have this concept of a pooled S&T. Today, I just want to discuss the difference between a first-party and a third-party S&T, and why one is sort of not better, but it's more optimal to have one over the other. A first-party S&T is set up with the disabled beneficiary's own money. And what I mean by that is that we may have someone who's, again, on Social Security or Medicaid, and they perhaps received a settlement from a personal injury lawsuit, or they receive an inheritance from a parent or a grandparent or someone else. And now they have all this money, and because of this money, it's a threat to their governmental benefits, which can be catastrophic for some individuals, especially individuals who are on Medicaid. So instead, what we do is we say, you can accept the money, and then we're going to say, let's transfer this money into a first-party special needs trust. The trust is going to provide for the benefit of the disabled beneficiary, but when the disabled beneficiary passes away, there's going to be a provision that says that any money that was laid out on behalf of the beneficiary by the government, in other words, if the beneficiary was perhaps in a nursing home and Medicaid was paying $5,000 a month towards that nursing home, and they did that for 5 years, whatever money they laid out on behalf of that beneficiary, they want to get repaid. So, and then whatever's left over after that, the disabled beneficiary gets to say, okay, whatever's left over goes to my children or goes to my intended beneficiaries. Unfortunately, most of the time there isn't any money left over in that S&T for the ultimate beneficiaries, and it usually gets absorbed by Medicaid or Social Security. So instead, we would prefer a third-party S&T. The third-party S&T is a trust that's set up by someone else other than the disabled beneficiary with the money that belonged to someone else. So when that money gets transferred into the trust, the disabled beneficiary will still benefit from the money. They'll still be able to have access to that money and make distributions. The trustee, not the disabled beneficiary, but the trustee, the person who's in charge of that trust, will make distributions to the disabled beneficiary or on behalf of the disabled beneficiary. And then when the beneficiary actually passes away, whatever money's left over, the person who set up the trust can decide where that money goes. So you can see how there's no payback provision, there's no mandatory payback of all the benefits. So you can see how one is obviously optimal over the other one. It's sort of, you're in a better position because you don't have to pay back all of that money. Now there is a little nuance and a little sort of thing that just to be sort of complete in this presentation, and what I want to say is that if you set up an S&T for a minor child, so let's say, God forbid, my son became disabled and I want to set up an S&T for him, and while he's a minor, I technically have an obligation of support because he's my child. So the government may take the position that during his minority there was an obligation of support, and there would be a payback provision at that point. And then after the age of majority, which is 18, then there's no obligation of support and there's no payback at that point. But that's a little nuance in the law. Your best option is always to sit down with an experienced elder law attorney or special needs attorney to discuss what options you have, especially if you have a child with some sort of disability, whether it be autism or cerebral palsy or something more severe like both bipolarism or perhaps schizophrenia. or it could be a physical disability as well. It's just really important that you sit down with an elder law attorney or special needs attorney who is experienced in handling matters like this, because you can really be doing an injustice to your children by leaving them everything outright without protecting them and protecting those precious benefits that they can be entitled to, and really makes a huge difference in their life.